Thank you, Harry. Thanks, everybody. Uh, as a normal standard line, as a lawyer, I have a very cynical view of things that happen around me. Uh, in any given new legislation that comes up or legislative changes that happen, we generally ask ourselves, what is this new animal? Is it really old wine in new bottle? Is it really a game changer? Or is it really an axis tilter, so to speak? Just to give you an example in terms of what these types of legislations are, we had this local body tax, which replaced octroi in Maharashtra typically. It's nothing but, old wine in new bottles. In fact, LBT created more problems than octroi. But octroi was a bad name and it got removed and got replaced by local body tax. So actually really did anything change? In fact, since the bottle was changed from old to new, I think the wine didn't taste well. So obviously I think the LBT created its own problems and challenges and everybody started saying, yeah, we didn't want octroi, but you got an animal which is kind of more draconian, so to speak. So we don't want LBT as well now. There are some legislations, and I can talk about the Companies Act 2014, which is really axis tilter, in as much as I think most of the companies in India have really changed the way they do their business or look at doing their business. So obviously it's an axis tilter. You're talking about a new animal called one-person company there. You had small companies, big companies, large, private, unlisted, listed, but now you have a new animal called one-person company. It's a Companies Act in that sense, with auditors' rotations and various provisions under the Companies Act, including class action brought in there. It may have been a reactive legislation to what happened to Satyam and other scams, but the fact remained that it's still considered as an axis tilter. Last entire financial year, this is 2014-15, we've been struggling to grapple with the new Companies Act provisions to say that, and I think the manner in which business is being conducted is changed. It's got OECD principles breathing down every company's neck in terms of corporate governance. Companies Act can be considered as axis tilter. When GST comes, I don't know where we are going to classify that. But if you look at FSSA, which is the Food Security and Safety Act, which came in 2006 but really became effective somewhere around 2012. After about 6 years, it started kind of getting various bodies in place. That's considered as a game changer. Why is it considered as a game changer? Is because it talked about, it broke away from Food and Drug Act. It was like the drugs and food were kind of considered together under FDA Act. It broke away. Food became a separate subject altogether. In as much as the food licenses in terms of safety and security, as well as food supply chain management became very critical from the point of view of ensuring that what food is available over the counter is of far better quality. It went into various certification and licensing processes. A very peculiar provision under the FSSAI says, if you're not complying with the provisions of FSSAI, but you have other systems in place, we will look at you positively, we will not prosecute directors. There's an obscure provision there under FSSAI. So probably that can be considered as game changer. Whether the Electricity Amendment Bill of 2014, where do we classify? Do we classify because the content and carriage is kind of being bifurcated as a game changer? Do you really believe that the entire electricity sector will kind of change the way it works in terms of axis tilt, in as much as you're talking about supply licenses being completely introduced as a new animal? I don't know. I'm just raising these questions. The answers are hard to kind of come. What has been the vision? And I think if we were to look at broadly what Harry said in terms of various provisions, how deep does this new kind of amendment go in terms of actually making an impact? Does it really work at a micro level? Is the question that we need to ask ourselves. Because that will kind of tell us what is the vision with which the changes are being brought and whether it is going to make an impact. Does it have a far-reaching impact in as much as does it have a telescopic view there? to say that we are looking at a sustainable kind of an environment across the energy sector in such a manner that it will sustain and kind of play with our vision of 2020 and beyond? Does it have those kind of impacts and provisions in the place? Or is it really myopic, very short-sighted? New government came in, wanted to do something, wanted to say that we've changed something and brought in these changes without really looking beyond a normal vision. Is it myopic? Is it hyperopic? And they've said, yeah, short term we are going to take care of. We don't mind taking care of the short term, but long term is still the problem. Very broadly, I think all of us in our childhood days, at least older generation or my generation, kind of loved Babaji ka Bioscope. We looked at slideshows through a bioscope, and I think that's rural India that you got to understand. Our mindset has been that of a Babaji ka Bioscope. We're not looking to broaden the horizons. We're looking in the bioscope to understand what are the kind of those slides that kind of we enjoy. Very quickly, I think in terms of renewables, see, of course, there's not too much of time in terms of saying that we can kind of analyze the legal provisions in terms of actually interpretative issues. But I've kind of picked up a couple of issues and I want to delve a bit into it. You know, Renewable Energy Services Company has been defined under the new bill, but where it is used, I didn't find where the definition has been used. We've look at the recent statements that are coming out, and these are primarily from various PIB releases that have come up. On February 17th, Mr. Arun Jaitley said that 266,000 megawatt commitments on green energy. I don't know what that commitment means, but they've said it's commitment. On February 17, they said that this expo, which was there, the Reinvest 15, showcased India's manufacturing capabilities and technologies in solar, wind, biomass, being used to provide an idea to the foreign investors about potential areas of investment in renewable energy. Now you're saying that you have manufacturing capabilities as well as technologies in these areas, but you're saying from the investor perspective, you want them to come here. How much amount of money has really gone in R&D for green technologies is a question that we need to ask ourselves. Can we really say that the photovoltaic PV kind of solar systems today are domestically manufactured at a reasonable cost? Again, state-specific policies on renewable energy is the need of the hour. Now, Railway Minister saying this, February 16 at Reinvest. Piyush Goyal, the Energy Minister, saying government assures protection of investment in renewable. And India government stands committed towards a cleaner, greener, better India. That's February 16 statement. December 8, again the Energy Minister said, 400 billion plan for fair returns on investment. What is fair returns? I didn't say anything in terms of at least the amendment bill that has come in. I don't know where this is hidden. To say that there will be fair returns for investment would ensure 24/7 power. And what? A loud statement made there. Make India the capital of green energy. Don't know what that means, but amendments don't kind of really reflect into what these statements are. Very clearly, I think Niti Aayog came out with the first document on energy sector. I think energy sector, all of us know, is the first kind of bashing field there. What she's saying there, what the chairman of Niti Aayog is saying, energy and renewable energy is the core area in India. We need to see actual movement on whatever the report, the Niti Aayog report suggested in terms of what the reform should be. We need to see actual movement on whatever the report suggests about. It's very important to say the chairman of Niti Aayog, the kind of new avatar of the Planning Commission, is saying that we actually need to see the movement. You see, just on the side, where the technology development is going, and that's insofar as renewable, insofar as thermal, I think we're moving towards wire-free electricity. There have been certain experiments across the globe which have been successful, where there is a wireless electricity transfer that can happen. What you really see on the mobile phones today, it's completely wireless technology where you're able to speak. Some time back, you were not kind of, even you couldn't have imagined a wireless telephone. I mean, today, it's a very popular technology. That's where the world is moving. And just to kind of take an example, that the Sela wireless tower that was kind of constructed couldn't get completed, and the technology boost didn't happen because JP Morgan didn't fund it. It thought that it is a crazy idea and large part of funding would be required to make sure that this tower starts transmitting wireless electricity. There is an investment that would be required on research and development, and we can't really say that we would be capital for green energy unless we really focus on R&D, and we don't see anything under this statute insofar as R&D is concerned. Just again, I can't really go all across, but taking an eagle's view on what are the provisions with respect to renewable energy. Before that, I would like to say the latest CERC amendments that I kind of talked about, the REC obligations. REC amendment, they've kind of got this floor and ceiling now worked out between 3,500 and 5,800. The primary motive appears to be that there were about 5 lakhs RECs which are in the inventory stage, not getting sold, not getting purchased, despite of whatever penalties that some of the SERCs that were trying to push across. The issue still is that there is an inventory of 5 lakh renewable energy certificates which are out there, which are stagnated. Nobody is buying them. So obviously this amendment regulation brought down the floor and the ceiling price. It was somewhere in the region of 13,500. It came to 5,800. It said that solar plants registered before the amendment, this is December 2014 amendment, will continue to have the vintage multiplier of 2.66 REC per megawatt. Now, that's something where we talk about retrospective, prospective operation. They're saying distribution licenses will now be eligible to sell RECs. What that really means is that, the sellers, there are more sellers that are coming into the market. And RECs will be valid for 3 years approximately. So obviously, whoever has done an investment in past based on the floor and ceiling that was earlier available, does that get saved, and does he continue to kind of look at floor and ceiling of 13,500? Because the commercial viability of these projects is primarily dependent on RECs that you're going to structure. Now, looking at in the backdrop of this, you look at what's happening in the current bill. It introduces renewable generation obligation on new thermal plants. It says 2.5% of new generation would be renewable. That's the obligation put on all thermal plants. All plants can go through with the consent of the procurer under the PPA. And that is kind of recognized under Section 7. Section 1411, generation and supply of renewable energy sources shall not require license. Talking about, decentralized generation, decentralized distributed generation capacities, you're saying RE sources shall not require any license. Whether the renewable power obligation under the new bill is in the realm of the state electricity regulatory commissions, and there is an obligation on supply licensee alone, are some of the questions that need to be kind of looked at in view of the bill. Now, there is obligated entity is defined under the definition clause. It means distribution licensee or consumer, owning captive or open access consumer. And RPO is really under the charging section provided only on supply licensing. We have had this problem in the recent legislations that are coming up, and this is a totally different issue. It gets into the realm of administrative law. When we look at a policy, and when we say policy is embodied in a statute or it's coming out of a statutory provision, the fundamental kind of a classical theory is that the policy is in the realm of administration. The courts, including Supreme Courts, at various points in time have taken policy making, policy implementation is left to the administrators. Judiciary will only look at whether there has been procedural impropriety or procedures have been correctly followed or not. They will never get into the administrative realm of the policymakers. There have been statutory policies, and one example of that is foreign trade policy. It works as a regulation. It works and it mandates actions at micro level when you're talking about foreign trade. That's a statutory policy. Under the Electricity Act, we've had this policy since 2003. Is it a statutory policy? We tried to kind of argue this at various forums to say that it is a statutory policy and it has to be implemented like you implement the foreign trade policy. But there is a confusion in everybody's mind, and this is now getting confounded by saying that there will be national renewable policy as a part of national energy policy. So, is it just a convenient statement? Is what I would want to kind of raise a question. Is it just a convenient statement to say that we would have a national renewable policy? Whereas, if it is flowing from the statute, you need to consider this as a statutory regulation like the FTP. Doesn't seem to be happening. It appears to be a convenient statement. Sorry, I think... yeah? I'm going to test now. Going back there again and again. See, if you look at the World Bank kind of a document, which is more power to India, and that seems to be the basis where I think some of the recommendations in a very sporadic manner have been picked up in terms of saying that we want to come out with something which is like a change in the present law. We need to bring out something new. This is a new government that has come in, new impetus has to be brought in. So it's picked and chosen from the World Bank report. What does the World Bank report say? It talks about two things. They're saying there is a need, and there's a need to new finance and business model emerging. That's, and it cites an example of Bhiwandi as a successful example to say that new financing and business model akin to a franchising should be looked at. Now, at least insofar as I am concerned, for me, Bhiwandi is not a representation of rural India. It's not rural India. They're also saying that the tariff inclusion and the subsidies need to be kind of bound together. How that's going to happen and how that World Bank contemplated it is a different story. Again, the World Bank very clearly recognized in its document, which is titled as More Power to India, is to say that discoms is a huge concern. Private operators are responsible for procuring power for their own consumers and cross-subsidizing the rural supply. That is the moot. And I think if you're looking at cross-subsidizing the rural supply, and that subsidization will continue, they're saying that identify that as one of the problems. And they said ring-fence urban and ring-fence rural customers. Consider license franchising and public-private participation model only for in the urban areas. Let the state discoms remain responsible for rural supply. I think that seems to be weighing very heavily in terms of the new amendment. They're also saying establish urban franchisee to encourage franchisee gradually to expand their services to cover rural areas. Will this really happen? I don't know. Some of the kind of problems that people are saying would get solved because of the electricity amendment bill. And if you look at carriage and content world over, I think there are 3 or 4 examples. I haven't really picked up UK here, but UK also has a mode in which it does the content and carriage thing. New Zealand experience is suggesting they really created a market administration, which is like they created a database of connection points. And that connection point database was very critical in ensuring that you have supply licenses or you have, let's say, carriage and content kind of completely distinguished there. They also said that consumer switching fund, which is the portability that we talked of. Let's look at telecom. I think in terms of telecom licenses, the portability, it took almost about 8 years for us to get onto the portability, and today you have these numbers which are portable based on whatever is the best tariff that consumer suits, it can create. The portability and consumer switching is going to be essential if you're talking in terms of distinguishing content and carriage. I think one of the most crucial aspect is going to be metering. If the metering across the energy sector is not rightly done, is not 100%, the content and carriage division cannot really work. That's the New Zealand experience. You talk about USA experience, they said that this content and carriage kind of differentiation has worked very well for largely depreciated generating units and not for consumers. Consumers may have had ability to port and switch, but depreciated generating units which afforded really a kind of a energy at much lower prices, they got benefited out of this because it's a scale at that point in time. So obviously that's what the US experience is. They're saying consumers are not getting benefited, but those old plants which have been depreciated, old generating units that have been depreciated are getting benefited. Again, EU, they're saying that it's a temporary fix. The content carriage kind of bifurcation, supply licensing is a temporary fix. 30-year cost recovery on investment is clearly a vulnerable issue. And we've had these PPAs which have been there. These are all long-term kind of contracts that we've had. Excuse me. The World Bank also talked about built-up of regulatory asset and how do you treat that when you're actually doing the carriage and content distinction. Most importantly, the World Bank's recommendation, and a very strong recommendation, thank you, sir, is that, and I quote here, it is probably wiser for India to start with pilot projects for retail competition rather than make a full-scale rollout at present. That's the World Bank very clear recommendation when you're talking about carriage and content distinction. And if World Bank is cautioning, saying that don't make this full-scale rollout at present because the country is not ready, I think we got to consider and we got to look at it very seriously. In terms of corporate governance, I mean, there is some talk in terms of institutions and regulatory build-up, but more importantly, I think the World Bank report also talked about linking corporate governance with performance of the utility. Now, what is the basic fundamental problem we've had in Indian laws is that cost of compliance with the law is really much higher than cost of non-compliance in the current regime. The new proposed bill says section 29 and 33, which talk about penalty not exceeding 1 crore for any breach of the orders under the Act, which would, and we'll have to look at if, let's say, a municipality or a distribution licensee or a supply licensee tomorrow does not comply with the renewable power obligations, that's a breach of the provisions of the Act. Will the levy be 1 crore and 1 lakh every day? That's what it says for a continuing offense. And therefore, I think we have to really look at and very seriously take this provision, because if the cost of compliance with the law is less than the cost of non-compliance, I think the people will move towards complying. But here in India, cost of non-compliance has always been higher. In terms of regulatory issues, you see, there's a cost of non-compliance today is much lower than cost of compliance. Did I say it the other way around? Yeah, sorry. Okay, in terms of actually the kind of regulatory issues and accountability that has been talked about very vaguely, even in the statement of objects and reasons for the bill, I think one of the very critical aspects is that autonomy, capacity, and transparency. Harry talked a bit in terms of capacity. I would want to touch upon in terms of autonomy and transparency. You know, how this is fanning out today under current kind of a proposed bill is that there is no deletion of Section 11. All of us in the energy sector know the kind of vagaries about Section 11. And I think Dr. Dev has been kind enough to kind of guide me somewhere last time on this, which is, why is Section 11 not being deleted? It talks about under extraordinary circumstances, giving power to the state government to direct SERCs, to direct the commissions as to what to do. Sorry, generators as well. So now what are the extraordinary circumstances, I think is a matter of interpretation which has gone up to Supreme Court and it's still lying in the Supreme Court. But the fact remains that there is an intervention. There is an intervention by the governments, and that is a big question on the autonomy of regulators. Secondly, there is a review mechanism currently. The review mechanism has two consequences. It says that Forum of Regulators will review functioning of the SERCs or functioning of the commission. So the commission member themselves sitting will review their own performance. That's what the kind of review mechanism talks about today, which is really leading to a question as to you are judging your own performance. Is it under law a quo warranto kind of a situation? I wouldn't know how far to reach there. Thirdly, I think regulatory capture in terms of actually saying that if the appointments under certain circumstances will be controlled by the state governments, is it really moving from state to center is the question again. The change in appointment and terms of the regulator may not be sufficient to kind of give comfort in terms of autonomy, capacity, and transparency. Cherry picking, Harry talked about it, Tamil Nadu Chief Minister is talking about it. This is a kind of a brief overview that I had to present. I'm sorry we can't really get into the details, but during question answer I'd be happy to look at it. Thank you very much.